great for creating the time for this session. I'm proud to say that Prof is one of our best in Nigeria, and indeed, I must say, Africa. I'm also proud that in the whole faculty for this initiative, I think Prof is one lecturer who is a lecturer, properly so called. He's a professor of law, and a senior advocate. If we were to pay Prof, I'm not sure we'll be able to afford it. And so I want to please urge all of you, please pay very close attention to this particular class. And as you can tell from the topic of today's class, is going to be a practical one, and it's going to speak to career development, as well. Prof is going to be speaking from his wealth of experience and of us also as a teacher of law. So on behalf of the Tolu Aderemi Initiative, Prof, I want to sincerely thank you, sir. And I mean that from the bottom of my heart. Thank you for creating that time. And thank you for joining us in impacting knowledge and building the next generation, of excellent lawyers and arbitrators. I welcome you again, Prof. Thank you very much.
Thank you very much, sir, for that welcome remark. So I would like to read the profile of our speaker today. So permit me, sir, so I can continue. All right, thank you very much, sir. Professor Bankole Sodipo, Senior Advocate of Nigeria, is a senior partner at G.O. Sodipo & Co., which was called to bar in 1986. He holds an LLM from the University of Lagos and a PhD in law from Queen Mary University of London, a specialist in intellectual property, technology, and allied rights. He has advised on complex commercial matters, FDI, M&A competition, corporate finance, and energy law for over 3 decades. He has also contributed to drafting legislation, served as professor and dean at Babcock University, and consultant for WIPO. He is the founding partner, president of iPlan, and current president of NIFA. Our keynote speaker or lecturer for today, Professor Bankole Sodipo, Senior Advocate of Nigeria. You're welcome, Linen Silk.
Mr. Kelvin, please, we can't hear you anymore. If you can hear us.
Kelvin, did we lose Prof's connection?
Yes. I think he dropped off. I'm trying to find him now.
Okay.
Apologies for that. He's going to join back shortly. Trying to sort that out. Prof, you're welcome back, sir.
Apologies. These things can mess one up. Well, I hope you can hear me.
Loud and clear, sir.
Oh, great. So can I start?
Yes, sir. I just read your citation shortly.
Yeah, apologies.
All right. Thank you very much.
So it's my pleasure to be here today, and I must thank the Tolu Aderemi initiative for this initiative. I understand that many of you have been on this course for about 10 or 12 weeks, and there's no urge to learning. He's been able to draw people from different walks of life in relation to what we are talking about, and I'm sure you've all been empowered. So today, what I just intend to do is just highlight some of the things I think you should have dealt with, at least just mention them, and then just dwell on career development, because that's what this is about. So it's like you have the knowledge. Now, how do you get the work, possibly? And I pray that some of the things I share you'll find useful over the next few years, and you'll remember this meeting as a result of this. So I understand that several specialists have dealt with issues of negotiation, mediation, arbitration, conciliation, early neutral evaluation, and expert determination. These are very interesting things. Looking at various aspects of ADR, and then emotional intelligence, even in dispute resolution, reading the body language of the people, ensuring that sometimes some people say they ensure that the parties touch and they're able to face themselves eyeball to eyeball. Sometimes you hear them shouting. Sometimes people break down crying. But at the end of the day, dispute is resolved. And then, of course, online dispute resolution. A lot of disputes are settled online. Lots of mechanisms. And then the hybrid and multi-tiered dispute resolution processes, where the clause on dispute resolution enjoins the parties to try one of these aspects, and then if it fails after 14 days or 30 days, they try another, and then if it fails, they then go into arbitration. And then finally, you also have dispute avoidance. Very interesting, because managing disputes, managing projects in such a way that you do not even have disputes. There's a radar, you smell it, it's like something is almost burning, and you don't wait until you start seeing the smoke. You are able to call the parties to order, and they start talking, and they're able to resolve. Sometimes the fear by some practitioners in this sector is that if the disputes are avoided, how will some of us earn a living? but statistics suggest that people can still earn a living because people can be paid for helping others to avoid disputes and to resolve disputes out of court. Maybe it's one of the things we could discuss later on. I was sharing with my Lord Justice in charge of the Court of Appeal mediation, ADR process, how a number of our cases have been resolved in the last couple of years. And, but our clients paid us. The only thing is that you cannot use those cases for my partners who had cases. Imagine 4, 5, 6 cases which you want to use to apply for silk to add up. So those are issues which the MPA needs to take up. It's not for here. So in the last 10 weeks, for those who may be, or for those who are not necessarily new, they are just trying to reinforce, they're trying to add on to their skills, I'd say there's been a lot of brainwashing, or should I say a lot of renewal of mind. Because ADR is for lawyers, is also for non-lawyers. In a study that our firm published a couple of years, we had 2 sets of studies. One was on the International Center for Settlement of Investment Disputes, and we looked at African nations who had ICSID arbitration instituted against them in the last 50 years. And we also had one for Nigeria, which was just looking at Court of Appeal decisions on arbitration related litigation. And those, the study revealed that several non-lawyers are appointed to handle ADR arbitration cases in Nigeria. I think some of the cases are significant. I think it was Savoy against Shonubi, where TM Aluko, who is an engineer, and possibly the father of the late Bankole Aluko SAN, was the arbitrator on a building construction dispute. So you could have non-lawyers sitting out in the last 10 weeks, I don't know. The reason for the brainwashing is that the litigation in most parts of the world, including Nigeria, is adversarial. And that is the training that lawyers have. And non-lawyers, even though they don't have the same training, but they've seen this adversarial nature of courts depicted on television. They've also seen it on internet programs. And as such, they sometimes have the same mindsets as do lawyers and judges. And that's why it's so important that maybe we should have some cleaning up of our brains, renewal of our minds. Because our mindset must change a little or be more accommodating. Because the ADR does not rely, for instance, on the strict rules of evidence. So some of the things which many people would want to object to in terms of evidence may not really be applicable. And that's why it's important to undergo this kind of programs so that you know that it's not the same way as it is in the law courts. Lawyers, for instance, find it difficult to keep quiet when they go into mediation and the mediator says, I want to hear from the client. Because in courts, you don't hear from the client, you hear from the lawyers. So that's why there's a need for this renewal of mind. And so enrolling in this kind of programs that you have undergone, hopefully would influence and build a new mindset. One of it is to learn to listen and listen attentively, maybe watch body language. I did allude to that. One of the sessions you had should help you to do for that. Also encourage you to remain neutral. Indeed, Yamaka, I think you should be muted. So the advocates for neutral in ADR arbitration should be ready to have partnership in their approach, because you need to be more flexible and more committed to substance of disputes rather than the form or procedure.
Sorry to interrupt you, Prof. Can you hear me?
Yes.
Kelvin, can you please mute Indy Diamaka back? Indy, because you need to mute your mic for interrupting the lecture. Thank you. I'm sorry, sir. Please go ahead.
Okay, can I continue? Okay, thank you. So now, many of us, are concerned about the future, and we're watching the times and consult one thing or the other just to give us the direction. The Oracle I consult says that knowledge is going to increase in the end times, and that we're in end times. That a lot of things will happen in the world, which we are seeing, wars and rumors of wars, earthquakes, famines. Now, the Tolu Aderemi initiative is just one of those things in terms of increasing knowledge and calling for continuous training. It means that it's a time to get more certifications, more degrees, joining more institutes. And that's why you will not be surprised that many professional bodies have continuous educational requirements. So whether you're an engineer, you're a surveyor, you're a lawyer, you're a doctor, you keep on having requirements to train and retrain. And looking at the dynamic nature of ADR, it is not an exception. And the reason for this is because you have new arbitration and ADR statutes and laws and regulations and policies that are churned out by parliaments, by arbitration bodies, by multilateral agencies. And they are churned out in response to demands and increasing developments. So the dynamic nature, regularly we hear or see decisions of judges on ADR, and based on those decisions, maybe new laws should be passed, maybe new approaches, and that's why it's important to attend and keep on reading. So, for instance, AI, challenges that the AI is bringing. Counsel use AI to prepare papers. Should arbitrators or judges use AI to prepare their awards? You may be surprised to know that almost all organizations, whether it's Chartered Institute of Arbitrators, UK, whether it's a Nigerian Chartered Institute of Arbitrators, whether it's a London Court of Arbitration, whether it's IBA, whether it's the International Chamber of Commerce, they are looking at AI and the challenges. They are looking at emerging issues surrounding corruption and fraud. I guess you may have been told or about one of the most significant cases in ADR in the last, and arbitration in the last few years concerning Nigeria. That's a process and industrial development case against Nigeria, where $6 billion was awarded against Nigeria, and it became over 11 billion. But Nigeria was able to set aside the award because we were able to prove that there was corruption in the face of the arbitration proceedings. So how should arbitrators respond to this? How should parties respond to this? So all arbitration organizations are looking at this and therefore refining and trying to churn out rules so that the integrity of the process will not be undermined. So leading arbitrators, you'll be surprised, also continue to undergo capacity building. Some of the top arbitrators in Nigeria, for instance, I see them attending programs, including some training sessions. The Nigeria in June, and where even if you are an experienced arbitrator, you need to understand how these rules work. So then you also have to realize that there are various levels of memberships in institutions. So you have associate members, you have members, you have fellows, you have chartered members. And so even though you've undergone this 10-week training, don't think that that's the end. I am a fellow of one organization. I'm a member of some other organizations, and some people are saying, oh, come and also do the fellowship of others. And I'm wondering, do I have the time? So you must keep at this. Now, another reason why you need career development and capacity building is because so you have people who do construction arbitration or mediation, sports arbitration, and there are institutions that are specialists for sports, for construction, and they will not appoint you if you are not a member or you have not undergone training there. You have organizations, so you have for sports, for instance, you have the CAS, you know. So you have for intellectual property, media, entertainment, the World Intellectual Property Organization has its own mediation process for, particularly for trademarks in the online world. And there are people who undergo their training, and you have those who do oil and gas. There are some people who are expert witnesses. There's some people who say they just do arbitration mediation that relates to investment treaties. Some people say I only do commercial arbitration. I guess most of what you have done has been in the last few weeks has been for commercial arbitration. But then there's also faith-based dispute resolution, Islamic, and also biblical. You have those who say, I do tax arbitration, family disputes, family arbitration, or employment disputes. So you may need to also acquire more skills in the ones that you need to test which are the lowest hanging fruits around you. Now, one important thing if you are in this sector, as in every sector, is to identify who the stakeholders are. Section 1, sub 4 of the Arbitration and Mediation Act 2023 states that parties, arbitrators, arbitral institutions, appointing authorities, and the courts shall do all things necessary for the proper and expeditious conduct of arbitral processes. Now, that section does two things. One, it identifies most of the stakeholders in ADR, and then it enjoins the stakeholders to do all things necessary for the expeditious conduct of arbitral proceedings. Who are the stakeholders? If you want to develop your career, you need to understand and identify the stakeholders, and possibly who are the big boys, who are the small boys in the stakeholders, because you need to align yourself to the stakeholders. Who are the stakeholders you can easily talk to? Who are the stakeholders you can easily fraternize with, and they come to know you, because those are the people that may give you work. So one is appointing authorities or institutions. That is, those people who often, let's say in a three-man panel, a party who to a dispute appoints an arbitrator, the other party appoints an arbitrator, then the two of them may appoint the chair of the panel. But in some agreements, they indicate that it is the Chief Judge of Lagos or Abuja Federal High Court, Abuja High Court, or Chief Judge of the Federal High Court, or a judge of a court that will appoint. Some of them say it is the chair of the or president of the Nigerian Chartered Institute of Arbitrators. It is the chair of the Estate Surveyors of Nigeria, or the president, and so on and so forth. So these people are able to appoint sometimes the chair. Sometimes the agreement may even say that they appoint all the arbitrators or the neutrals. If you go to the Lagos Court of Lagos Multi-Door Court, that institution appoints the mediators. The Court of Appeal, ADR procedure, the justice of the Court of Appeal appoints. Can you hear me? So
Very loud and clear.
The appointing, thank you very much. Those are the appointing authorities and institutions. And so you may need to know them, because they are the people who may instruct you, who may appoint you. They may be regulators. So for instance, the Nigerian Communications Commission, and now the Nigerian Copyright Commission, the Electricity Regulatory Authority, the Petroleum Distribution agencies, regulatory authorities, maybe estate surveyors and other bodies of that nature. They regulate, and they also insist that certain disputes can only be resolved through them. Therefore, it's important to know them, because they may be the ones to appoint. Then parties, of course, and sometimes it may not be the parties, it may be the counsel to the parties. So for instance, I've had opportunity to appoint arbitrators when I'm instructed by some multinationals, and I'll tell the multinationals that X is the person I want to appoint, or Y is the person I want to appoint. I appoint you as counsel, but I also appoint the arbitrator or the neutral, not you appointing. So it depends on the party. It may be counsel, it may be the party himself. Then the Arbitration and Mediation Act did not mention registrars or secretaries. Many of the institutions or many arbitral processes and many ADR processes would need somebody to take notes, somebody to manage it and communicate with the parties, who may be the registrars, maybe secretaries. Then other stakeholders will be expert witnesses on the law. So there are some people who say, yeah, I do arbitration, but I act only as expert witnesses. So for instance, some judges and some senior counsel, including senior advocates, but they are regularly appointed as expert witnesses on the law. Some non-lawyers, like accountants, like engineers or surveyors, may be appointed as arbitrators, but they may also be appointed sometimes as expert witnesses on issues, maybe on damages, maybe on on the facts. You know, was there how much should the rents be? How much has been spent on that project? So maybe surveyors, maybe forensic accountants. So you could be experts, and all these people play in the AR space, but you play different roles. And I must tell you, some of them earn good money. Many of us, or many people, just think it's only arbitrators that earn money. Sometimes counsel may earn more money than the arbitrators or neutrals. I mean, most of the cases are the multi-door or the Court of Appeal, mediation, ADR. The lawyers earn more. And the typical case I use for my students, particularly the master's and PhD students, are the Interocean against Nigeria, where it was an ICSID case at the International Center for the Settlement of Investment Disputes, DC, and the arbitrators were paid between, I think, 300 and about 600,000, if I can recall. Meanwhile, the witnesses were paid between 25 and maybe 100,000, but the counsel were paid maybe about between 1 million and about 4 million US. So there are cases where I have also earned more as counsel than the arbitrators, and I got an appointment not long ago where I also would have charged more as counsel than what I was being offered, but because it was a very interesting issue, I agreed to the fees. So the next thing we should ask is then, are you really appointable? You've done this training, 10 weeks, and I hope you've been dedicated, but are you appointable as a neutral? People want to ask you, what experience do you have? Because they want people who have experience and not people who are using their case to test how to drive. Trust. Can you be trusted? Will you remain neutral and impartial? or you get excited when you hear the figures or get emotionally involved with the issues, and you may not be able to handle. Thirdly, are you visible to stakeholders? So you have experience, you have trust, you have visibility. As you build your career, all these are important. So do they know you? Do the stakeholders know you? Do the appointing authorities know you? Does the Nigerian Communication Commission know you? You want to do telecoms ADR. Have you written them? Are you registered with them? Do the courts know you? The Communications Commission or the estate surveyors, those are regulators. The courts who appoint from time to time, do they know that you do ADR? Do the institutions know you? Are you a member of the institution? I have lost some appointments because I'm approached and they said, oh, we wanted to appoint you for this, but we just realized you're not a member of our institution. So what do you do? Go and register with our institution. The fact that you are now registered with them doesn't mean you will now have an appointment tomorrow. You may not have for maybe another 2, 3, 4 years, and you must still keep on paying your dues. I've also lost appointment because I did not pay my dues to an organization on time. So an opportunity came early in the year. You know, MBA says, for instance, you should pay your dues by March. Please pay it in January if you want to. I mean, because our opportunity may come in January for appointment. And then they say, oh, this person has not paid his dues. So because somebody wants to appoint, there are 1 or 2 other people who may just oppose and say, but sir, this person has not paid the dues. And they may not want to say, quickly pay your dues so that we can appoint you. So since then, I've learned that early in the year, let's just pay all dues. It must be part of your budget. So you must ensure you are listed. So even as I'm talking to myself because there are like 1 or 2 days back, I went into an institution to say, look, I've known you for years. We do things together. But I'm not listed by you. I want to be listed. You know, if you don't ask, sometimes they won't list you. And if you are not listed, you will not be called. So sometimes the list expires, like the ICSID list in Nigeria sometimes expires. You find out the people who are on the list, their term has expired and they've not been renewed. For many African nations, when we did the ICSID study. So what must you do so that you be appointable? Ensure you join those institutions. Ensure you attend their meetings and conferences. And don't just be quiet when you attend. Mix. You can say, I am shy, yes. But even shy people can talk to 1 or 2 people, one-on-one. So this means you may need to devote money, like a war chest. I've done this training now. I want to move to this level. I've done this. I want to move to that level. So don't, you may be very fortunate that immediately you become a member, they appoint you. But I was teasing the chair of one of the institutions to say, you people are just you just appoint yourself, you don't appoint other people. And she said that she became a fellow of the institution 10 years after becoming a fellow before she got her first appointment. Meanwhile, some people are not fellows and they are getting appointments. So pray, because it's not just spending money, it's not just being visible. But you probably need to keep telling people appointments. I'm available for appointments. Don't be shy about it. Now, how do you get the experience? After attending meetings and so on, some of us may need to volunteer pro bono. You know, you may join and say, I want to work with these institutions. I had wanted to x-ray the lives of some people who have become King's Council top arbitrators today, and they started from the Mauritius court. They started from this other institution as volunteer workers and as registrar, as this, as that. There are people who, top arbitrators in Nigeria, who are members of the ICC court, International Chamber of Commerce Court of Arbitration. And when you are a member of the court, I mean, the nominations body in Nigeria, the ICC nominations body, cannot appoint you. We cannot appoint you because you're a member of the court, because the court is going to review the decisions. So it means that if you're on the court for 4 years, or you're appointed for another term of 4 years, for 8 years, you may not get an appointment. But when you are there, you are traveling to Paris from time to time, maybe once a year. You are attending several court sessions, reviewing so much work, but you are learning. You are fraternizing with people. Your name is going out there. And they know that, oh, this person has been a member of the court. So they can trust you. Okay? You may seek to attend hearings. I mean, some institutions can allow people to attend, subject to the parties saying yes, they don't object. Some arbitrators in ad hoc arbitrations can allow people to say, look, I have some mentees that will be attending the arbitration with me. I hope you don't mind, parties. And the parties may say, no, there are too many sensitive issues. We don't want them. Or some will say, oh, that's all right. People need to learn. So seek to attend hearings, seek to be part of hearings. At least you can glean from that. You can learn. You can watch. You can also watch videos. There's some a few arbitration cases that you may see on the internet, particularly litigation related to arbitration at the Supreme Court of England. You'll be surprised. The Court of Appeal, you can see that. There must be hope, because after spending money, and no appointments, that is a complaint I have seen in several organizations in Nigeria. Many people say, I'm a member of this, your institute. I've been a member for years. I've never gotten any appointments. I'm just paying money. I'm just paying for training. And the registrars may say, sorry, we never promised you that you get appointment once you become a member. But there's hope, because recent statistics show that there's a move towards diversity in most institutions. So more women have been appointed. The report that was just released for ICC court, which is one of the most popular, last year showed that 54% of arbitrators appointed were women. So more women were appointed than men. This was not the case years ago. And there's more diversity in even geographic appointments. So it's not just, they are trying to appoint more Africans. And because of that, they had a training program last year, I think for last year and possibly for, where they allowed maybe about 5 from Nigeria, 5 from different parts of Africa, and they had to go to about 4 countries in the world, I mean in Africa, for training. And the people who offered the training were not paid. Then you, who are attending the training, you are paid. I mean, you pay to attend, and then you fly all around. And the people who attended the training were top. They are already established arbitrators, but they were still attending this ICC training because they want more appointments by ICC. Because ICC would say, for instance, oh, they've not handled any ICC arbitration before. Therefore, we cannot appoint them to chair a panel. But the parties may appoint them as party nominated arbitrators. And so, what are the routes that have been undertaken by some? What are the stories that have been told by some ADR practitioners? Some will tell you that they devoted so much money, and they plan that over a 2-year period, some over a 5-year period, they want to get certification from this organization, certification from that, so that they open more opportunities for themselves. Some would say, look, I just want to do arbitration locally because I don't have those kind of funds. But then, like I said, you need to be known by the appointers, who could be clients, who could be institutions. The biggest client in most of Africa is the government. Some of us don't like to do government work. But the government, through the Attorney General or some ministers, will be the biggest appointer. So, for instance, MP has a lot of arbitration. The minister in charge may influence appointments. The Attorney General may influence appointments. Minister of Aviation, I know, influence some appointments in some matters I've been involved in. So Attorney General's department certainly has a say in many. And so those who have worked as Attorney General or who have worked in the Attorney General department often see a lot, and they see the opportunities. And because of that, a lot of things happen to them. One of the oldest arbitrators in Nigeria now, Chimizo Ekunle, was working in government. And through working in government as a civil servant director, went for negotiations of a lot of things. And she went for a lot of training. And of course, she's a name mentioned all over. Don't want to mention some other names. People who've worked in law firms where they do arbitration, or where their bosses do arbitration. They've also been exposed, and therefore they also know the clients, and appointments come. So those who work in legal departments of parties who go to arbitration a lot, the NMPCs of this world, the multinationals, those who have worked with non-arbitrators, like I said, those who have worked with regulators, you've worked with ADR institutions, so your face is known. Some of the emerging arbitrators today, I don't want to mention names. I mean, a lady, a Kenyan lady who's worked in ICC for years, before setting up on her own. I mean, she's blossoming. I know the director for Africa for ICC recently retired or resigned or whatever, and joined a firm. And because she's known, she probably will be getting appointments. Even if it's not ICC immediately, it could be part, but it could also be ICC to check on some arbitrations. You must be known by the judges. Some of us are known by judges, but the judges don't know us to be arbitrators. I remember in my early years as a lawyer, I was in court and there was a dispute. It was a property development, construction, family dispute, and the property was deteriorating. And the judge just looked and said, "Mr. So-and-so, do you mind? I want to appoint you as arbitrator on this matter." and you also be a receiver, sorry, on this matter. You'll be collecting the rents and so on. So it is possible for there to be references like that. Now, one of the best ways of getting known, particularly for some of us who say, I don't have money to be attending so many conferences. You need to attend some. You need to attend some. I mean, local conferences, regional conferences, Ghana, Cameroon, Rwanda, they may not be too expensive. The ones in Nigeria where international people are coming, at least so they see your face. Sometimes online programs, and try and ask very reasonable and significant questions that may catch their attention. Then try to write and publish. One of the, I think, main partners in the founding partners of ALEC saying to young arbitrators recent at a meeting, young aspiring arbitrators, that he traveled with some folks in his firm, young senior associates and so on. And when they travel, the younger people were accosted by people and say, "Oh, you are from Alex. Oh, how is X?" And they went to several meetings and people would say, "How is X? How is Y?" I was like, "Why are you asking about X or Y?" "Oh, I read their article on so and so. I read their blog. I read their publication on so and so." So when he returned, he told the people who didn't travel that you did not travel, but you traveled. So writing is significant. I was a very playful undergraduate student because I was involved in Christian activities, and I thought, oh, serving God meant sometimes I lectures, those were more important. I was wrong and sick, and I lost a year. And Justice Eshaw, when I asked him to sign my what's it called, my bencher's form, was reluctant. So why should I sign? You spent so many years. It was supposed to be this number of years. You spent an extra year, and he signed it reluctantly. But a little over a year, or I think that same year. No, that was before I was called. Okay, so the year I was called, I was serving. The Supreme Court handed down a decision, the first decision on copyright. And Justice Shaw headed the panel. He didn't write the presiding judgment. And I reviewed the decision of the Supreme Court. And I argued in a humble manner and showed that that decision was arguably par incurium. And I sent it to his lordship. He wrote me a letter saying if they had read that judgment, what I had written before the judgment, they would have arrived at a different judgment. That was very encouraging to me. And within a year after that, at meetings, he would introduce people to me to people and say, "Oh, this is my son." There was a time when Charlie Boy, my client, had an issue with Justice Shaw's niece, who was Charlie Boy's landlord. And the two of them were now arguing. Okay, yeah, this is Charlie Boy's lawyer. This. And Joseph said, "You want to introduce Bankole to me? He's my son." Okuta said, "No, he's my son." They were arguing over me because I had written. So I encourage you to write. Because people will read. And when you write, you analyze very well. You are at meetings. I have challenged the lawyers that do the P&ID case for Nigeria that we won. And when they made some assertions at meetings, and I said, no, that did not happen. Because I read that case over and over. I wrote about 3 articles on various aspects. That helps. So it's also possible to appear as co-counsel, and at least you can say, I acted as counsel. I act as counsel. So you are doing arbitration, not necessarily as arbitrators. For speaking opportunities, sometimes you may have to pay. And for some of us who say, I don't have money, or you don't believe in paying, then you may not have that speaking opportunity, but you can ask questions or make comments during the program. And those comments or questions, I remember, whenever I ask questions or make statements, often the speakers would, during TIF, we were able to, oh, that question was this, and so on and so forth, and then other people notice you. Then internships and attachments, pro bono work, these are very vital. Now, I want us to conduct an experiment as I close. Yes, I've made a lot of suggestions, but what you can try over the next 1 year would be that in drafting agreements, you put an ADR clause in the agreements that you draft. I'm sure you draft tenancy agreements, shareholders agreements, supply contracts, some building work agreements. Put a mediation clause. Don't go and put ICC arbitration, it's expensive. Just put a clause of mediation, arbitration, sole arbitrator, this. And then if a dispute arises, you'll be the one to appoint the arbitrator or mediator on behalf of your client. And then you can appear as counsel in the proceedings. You can then ask the party who you appoint today that tomorrow they should appoint you as mediator or arbitrator. Are these, I put is this, I'm sorry about that. Are these possible scenarios? I think yes. And if any of these occur, and you are drafting, people say, do you do arbitration? You can say yes, because you draft arbitration clauses. You can say yes because you appoint, even if you are not counsel, or you advise on appointments. You can say yes because you appear as counsel, and then hopefully you may be appointed tomorrow. These are just some tips, and then pray, because the race is not for the swift. Sometimes I've marketed myself to some major law firms abroad, not knowing that the people that handle the cases in Nigeria are not the partners. And I know all the partners. Meanwhile, it's one small girl who is a paralegal that handles Nigeria and are not friendly with that girl. So God leads and guides us. I think I will stop there. I hope you've learned a thing or two, and thank you for this opportunity. Thank you very much. I hope you are hearing me.
Prof. Loud and clear, Prof.
Ready, sir.
Great. But I'm not hearing anybody. I hope it's on my network.
Thank you very much, Doc. Please confirm you can hear me.
No, we heard you clearly, sir.
Can I hear you, sir?
Wait.
Okay, thank you very much, Prof, sir, for that insightful session. Please confirm you can hear me also.
Yes, we hear you.
Perfect. Thank you very much once again, Prof, and for giving us out of your wealth of knowledge this session. I think one of the things that stood out for me was the part where you said we should market ourselves even more. Write and put yourself. It just solidifies the points that my mentor, Dr. Tudade, always say. Right, no matter what. You think one person is not looking, right, put yourself out there. Go for events, speak. Even if you don't have any question, contribute. Raise up your hand and actually do. And I think I buy into that, and I really appreciate you. And we are going to have the floor for questions in the next 10-15 minutes. We are going to open the floor for questions, and anybody that just have questions, just signify, and then we are going to be asked to unmute.
Any questions, please? All right. Ulugbemiro Shubaki, you have the floor. Thank you.
Okay, hello. Good evening, sir. Good evening, facilitator. I just wanted to say, in addition to what our facilitator said, there's a program coming up between 3rd to 6th of June. Nigeria is an ICC event for Africa. So I don't know if you search for it, it will be beneficial to those of us here, although you're going to pay at least 250,000 or 150 to attend. For those of us interested in arbitration or ADR. So that's just what I wanted to say.
Yeah, thanks for marketing that. Incidentally, I'm the chair of the program subcommittee. It's a very going to be a very, very rewarding program in terms of capacity building. And then networking. You meet local and regional and non-African folks.
Thank you very much, sir, for that. Please, I have another question. Odegai from Modupe Olua. You have the floor.
Good evening, everyone. Thank you so much, sir, for that insightful lecture. I'm a 400 level law student at the University of Lagos. So my question is this. Sir, what challenges or mistakes did you face early in your career, sir? And what advice would you give me to help me navigate this professional world maybe after I graduate, sir? Thank you, sir.
Yeah, just read. The best lawyers read. And then don't be bashful, don't be shy. I was at the Regional Center for International Arbitration some years back. And my classmate, the Attorney General at that time, asked, this was maybe about 15, 20 years ago, about arbitration. I should have pushed myself. It was later that I realized that, I could have gotten appointments just like that. So don't be bashful. Approach meetings prepared, meetings with people, conferences, and ask prayerfully, what am I going to do here? Who am I meeting? What should I do when I meet them? See meetings sometimes as once in a while, lifetime opportunity, because you may not meet those people again, or if you meet them, you may not have opportunity to maybe chat them up. So have something you want to say or ask, particularly on something that would strike them, not something, if it's arbitration, then maybe recent cases, recent development, new rules, new laws, or maybe statements made by people, and then just look for a point of discussion. And then I think I've also been a little careless because I was just so satisfied with my intellectual property work. We were very busy as a person, as a firm, and I didn't care. In fact, even getting a silk, I never bothered. But anything you can get now, get it. Any organization, institution, you may be able to get their certification, get it, because knowledge will increase. That is a given. That is what's one of the things the knowledge that's increased in the last 20, 30 years. It's mind-blowing. When I did my PhD, there was nothing like GSM, there was nothing like internet. So you can imagine just in the last 35 years since I did my PhD. And it's going to get even more challenging. So just keep on getting knowledge, challenging yourself. Let me stop there.
Thank you very much for that.
Thank you so much.
All right.
Okay.
One more question.
Can you hear me?
Okay, yes, loud and clear, sir.
Thank you very much. I wanted to thank Prof. I think that was a master class. And just to feedback on one important point Prof made, and it would be by way of example. Prof talked about visibility. And for those of us here on this platform, in the last 10 weeks, we've spent time equipping, this classroom intellectually. But our job here at this initiative is not just to equip you intellectually, we also want to prepare you for the market. And so if you hear people like Professor Sodipo, they are a combination of the two. To be honest, how Prof does it, I wonder sometimes. There are places where, I will attend back to back, and maybe on the last day, I'll probably think, look, because I'm younger, I should be able to attend this program. And I get there and I meet Prof there. Prof is probably sitting in front, getting there ahead of me. And so you can never be visible enough. You must demonstrate to people your preparedness, your ability to assist. I was in Miami some years ago for the ICC conference. And I remember when we were going, the president of the ICC Arbitration Commission, Professor Dorothy Uford, she told me something I'll never forget. She said, look, this Miami, all of us are going. She said, just make sure that you are visible there. So, it looked like a cliche. Everybody says it. And when we got into that room, it was a room of almost about 1,000 people. Now, first problem was it was 1,000 people. Second problem, almost about 900 were white, or maybe 950 were white. So we that are of color were not more than maybe 20 or maybe less. And I said, Professor Dorothy Uford must be quite wicked. How would she expect me to get up in this kind of, and the 100 people consider them to be some of the best in arbitration across the world. And so know that before you open your mouth, and this is why intellectual ability is very important, read widely. Everything you can pick up on, read it. So I said to myself, wow, if it's just for the money of flying to America, or the money for booking a hotel, or even the money for paying for that conference, because some of this conference, like Prof said, you also have to pay for them. And when you look at the cost of how much a nice suit will cost you, or how much a Chanel bag will cost you, vis-a-vis how much you pay for those conferences, then you are better pay for the conferences. Because one deal or two deals from those conferences will buy you 10 Chanel bags. And so whilst I was in the hall, I was just, it was racing through my mind, what was I going to say? It must be so important. It must be intellectually laden. At a point, I don't know, maybe it was the spirit, just picked me up. And it's not like here where they bring the microphone to you. No, you walk through the aisle to almost the center of the hall to ask your question. So your question had better be important. I can't remember what question I asked that day, but I went. And what is the outcome of what happened to me that day? Almost 2 appointments. Beyond that, I've created newer relationships. So today, because of that particular meeting, if I'm looking for any foreign counsel or arbitrator or anything across any of those jurisdictions, I have people from that conference that I met across almost all the jurisdictions. Talk about the big law firms too. I was able to create relationships across board. So the point I'm making is, please take this part of it seriously. We brought Professor Sodipo to come and convert all and you can see that he mixed the two. So all the intellectual deposit, for you to understand that if you keep that intellectual deposit just in your mind, it remains in your mind. But if you are able to sell it, and how you sell your intellectual deposit are some of the things Prof highlighted to us this evening. Prof, thank you very much again, sir.
My pleasure. My pleasure. Thank you for the platform.
All right. Thank you very much once again. I hope we don't have any more questions. Okay. Okay. All right. In the absence of no other question, I want to say thank you once again, Prof, for this insightful session. Thank you for taking out time out of your very busy schedule to inspire us and give us more insight into this subject. Thank you very much once again, sir. And to all participants, I want to say thank you for taking out time to be in this class. Thank you I hope you are taking notes, and I hope you have plans to put yourself out there. Thank you once again, and have a beautiful weekend.
Bye.
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 All the best from
Thank
Ghana.
you. Bye.
Bye, everyone.
Bye.